Welcome, everyone. It is great to have you all here at FOREP Council's webinar, Patent Holdout and Smaller Technology Firms. My name is Claudia Tapia. I'm president of FOREP Council, and I will be your host today. As you may know, FOREP Council is a non-for-profit research organization focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and stakeholders. On our website, you can find plenty of free materials, for example, studies, guidelines, summaries of relevant papers, and recordings of our webinars, like the one today. And we also produce easy to digest content, specially tailored for non-IP experts, SMEs, startups. Our aim is basically to assist innovative startups and SMEs in learning how to use IP to grow their businesses. And if after today's webinar, you are interested in exploring more the topic of patent holdout, and you will hear Bo talking about this today, you can find more information on this topic in other relevant papers available in our website. So I encourage you to look and try to see if you find something on this. As you know, the Internet of Things is playing and will play a huge role in our societies and economies. And one big important pillar of the Internet of Things is standards, cellular standards, which, as you know, are often protected by patents. The good news is that they are available for licensing. So to help you to better understand what will be or what should be your behavior as a licensor, but also as a licensee of these patents essential to the standards, in a good faith licensing negotiation, we have created a corner, a case law area in our website with summaries of court decisions dealing with these kind of negotiations. And without further delay, it is my pleasure to have Dr. Bowman Hayden and Matthew Rupp with us today. Dr. Bowman Hayden is currently co-director of the Center of Intellectual Property, CIP, which is a joint center for knowledge-based business development between the University of Gothenburg, Chalmers University of Technology, and the Norwegian University for Science and Technology. And he's also visiting professor at UC Berkeley, visiting scholar at the Hoover Institution at the Stanford University, and member of the European Commission High-Level Expert Group on Standard Essential Patents. And on the other hand, Matthew Rupp is the general partner of Future Frontier Capital, a pre-seed frontier technology venture capital fund. Matthew co-founded IP Checkups in 2004. And for those not aware of it, IP Checkups is an intellectual property strategy and software firm where he managed hundreds of innovation projects for early stage startups and large corporations. Matthew is also teaching at the Funk University Institute of Engineering Leadership at the University of California, Berkeley, and project manager for the Deep Tech Lab at the Haas School of Business. So as you know, a lot of knowledge in both sides. I'm super excited that they both agreed to come today and to discuss this topic that we will hear in just a few seconds. But before that, a final remark for the audience. Please do not hesitate to use the Q&A tool to submit your questions. You can find it in the lower part of the screen. You can raise questions anytime, during and after the presentation. And the questions will be addressed following the presentation. So, Bowman, the floor is all yours.
All right. Thanks, Claudia. Thanks a lot for inviting Matt and I here. When you read out our bios, it sounds very like we're very busy. So makes me.
Impressive.
That's right. But Matt and I have been working a lot on intellectual property in relation to small enterprises, especially at Berkeley and with the venture fund that Matt does. So we've been thinking about these issues a lot together and discuss them. So we're very excited to discuss our paper and take questions later. So we can go ahead and get going. I think that the first thing to discuss then is when you start to talk about patent holdout, it's part of a continuum. It's part of a set of competing theories of market failure. Patent holdout is a transactional concept, just like patent holdup. Somebody is transacting patents, and then there's an issue in how that market is functioning. So the first thing to understand is that going back to Kenneth Arrow, the Nobel Prize winner in 1962, he wrote a paper about the information paradox, which talks about the challenge in forming markets for non-rival goods like knowledge. So in other words, people would say, well, I have some valuable knowledge, and someone would say, that's very good, let me take a look at it. But if you show it to them, then they're not willing to pay for it because now they already have it. So intellectual property and patents are critical in creating markets for knowledge where disclosure would destroy the value of it. So patents start out as a remedy, as an institutional solution for this type of market failure and transaction of knowledge. Then in around the late 1990s and the beginning of 2000s, there start to be more discussion that there's so many patents out there, that there's thickets of patents, and that people had weak patents, and that the weak patents in combination with injunctive relief would give people a chance to, as Lemley and Shapiro write here, to negotiate royalties far in excess of the patent holder's true economic contribution. So now patents and the patent system are considered to be something that's blocking the proper transaction of knowledge and blocking innovation in a way instead of helping it, as was discussed before. A lot of changes were made in the United States to the system through judicial rulings and legislations. And now we could argue that the pro-patent era that started in the beginning of the 80s turned to a more weaker patent era now in the last 2 decades. And now the concept of patent holdout, which is the opposite of patent holdup in the sense that companies, the accused infringer is seen as opportunistically blocking the patent holder or the licensor from capturing the true value, true economic contribution of their patents. And you can see as a patent system becomes weaker and weaker, we start to come full circle back around to the whole idea of why we needed the patent system in the first place, as Arrow discussed. So again, we have this kind of journey. And you can see here I've highlighted a few terms. So in Lemley and Shapiro's definition, we have the concept of true economic contribution. In Epstein and Nowruz's definition of patent holdout, we see the terms of good faith, valid patents, infringement, extracting a license payment. And in this way, we would say extracting a proper license payment, or one that is equal to or close to the true economic contribution. But all of these concepts are subjective, which makes it difficult to nail down these concepts in an easy to understand and easy to observe way. So this is what we'll be focusing on in our paper. And so one thing, Farrell and Shapiro, during the height of the patent holdup discussion era in 2008, asked the question, how strong are weak patents? So very much what we're asking in our paper now as well. How weak are strong patents nowadays? So let's ask that question. And in this regard, we have a framework that looks at 3 different areas. One is the relative weakness of the system now and its ability to sustain small companies' ability to transact intellectual property. The other one is the behavior of patent holdout. And the third one is the impact of patent holdout. So we'll be looking at the patent system in total, and we're looking at the behavior of individuals and then the impact of that behavior. So if we've broken up in our paper the idea of analyzing the kind of intrinsic understanding of the patent system and the extrinsic challenges. So the intrinsic, is that these are the fundamental difficulties that are inherent in trying to capture technology-based technology in a property rights system. So for example, the cost of judicial action. In the United States, it's extremely expensive. It's extremely expensive to even take a look at what's going on if you receive a letter in the mail. And it can go up into tens of millions of dollars, which are in the cases that we discuss in our paper. So how does the fact that it's so expensive block small companies from being able to participate, given the fact that their finances are limited? The next is the length and the time of adjudication. It takes a long, long time to adjudicate patent cases. Some of the ones we looked at, which we'll discuss, have gone on 4, 5, 6, even 7 years, sometimes without a complete full decision and a remedy that actually sticks. So small companies don't have a lot of money and they don't really have a lot of time to wait. The last one is the subjective nature of patentability and infringement. So fundamentally, it is always a bit subjective of whether patents are valid and whether they infringe. So the fact, if you can take multiple looks at these types of issues, then you will, of course, over time, possibly find a way to find a patent to be invalid or not infringed. So these are fundamentally subjective intrinsic issues. On the extrinsic side, we talk more about the things that come and go over time. So we had a pro-patent era that started in the 80s. Now we have a more weak patent era. And we've seen changes to patentability criteria, such as eligibility and non-obviousness, which has made it more difficult for patents that are granted to remain valid. We've seen changes to equitable remedies, injunctions in eBay being taken away, the way the damages are calculated being reduced. We've seen administrative procedures such as PTAB added. All these things, for the most part, have made the patent system weaker from the patent holder's perspective. And of course, there's technology change and convergence. In the eBay case, for example, it had a lot to do with multi-technology products, which are a phenomena that's more recent. And how do we handle that in the patent system? And so certainly one of the justifications of the ruling was because of this technology convergence. So one of the key areas that Matt and I spent a lot of time discussing was this issue of patent holdout behavior. This is the second one. Is it bad faith or is it rational? And in this regard, we would have this discussion about the legitimacy of granted patent rights, the use of market power against weaker actors, and the lack of reasonable royalty payments in a reasonable period of time. So we looked at these issues. You know, every actor will question. If someone is accused of infringement, everyone will say that the patents that they don't infringe and the patents are invalid. So just the statement of that can't be bad faith in itself. So the question is, when does the challenge of an alleged infringement become bad faith behavior, or is bad faith behavior now institutionalized into the system? When it comes to market power and weak actors, when is petitioning a court to resolve a dispute, or when is an actor just petitioning a court to resolve a dispute, and when is it using litigation opportunistically to overwhelm a weaker opponent? So when does the use of superior market power position constitute bad faith behavior, or again, is it institutionalized in the system? And of course, when it comes to delay, when is it a question of due diligence and proper due diligence and negotiation versus strategic delay? So when does the delay of payment become bad faith, or is it institutionalized in the system? So we keep coming back to this idea of institutionalized into the system, because we created this little graph here. On the bottom axis, we have patent system strength. On the y-axis, we have bad faith standard. When the patent system has no strength at all, it's almost as if there is no patent system. So if no one would ever enforce patents, then what would bad faith and good faith mean in a system like that? there has to be a certain level of strength in the system to even differentiate bad faith and good faith behavior. So as the system becomes weaker and weaker, are people acting in bad faith, or are they acting within the rules and guidelines of the current weak system that's not able to uphold the rights of patent holders? And the last area that we looked at was the economic impact of patent holdout. So in this regard, we used a framework that was used from a paper that I wrote with Nicolas Petit not that long ago in 2017 to kind of frame the idea of impact, because we know impact is the important measure. So the question is, does patent holdout behavior create a substantial economic impact? It's one thing for people to behave in a way that could be considered opportunistic. It's another thing that actually has an economic impact. And we looked at this on the firm level and also on the society level. So from an economist perspective, economists would be focused on public policy, would not be concerned with the distribution of the pie unless it affects the size and the quality of the pie. In other words, if one actor makes more money in a deal than another, from the big picture, it's still the same. But if one set of actors start to be benefited all the time, how does that affect the whole economy and how it operates? So from a policy perspective, you're looking at the whole economy. Obviously, from a company's perspective, you're looking at whether winning and losing in any circumstance is important. So when we look at this, we try to say, is this a circumstantial effect? So is this just bargaining positions that are somewhat better or worse between actors, that if there was some line of what the proper result should be, sometimes people do better, sometimes people do worse, better, worse, that kind of comes out in the wash. It's just a distributional aspect. It doesn't change the way the market functions. The next level, what we would call systematic effect. This is when the pattern would be on one side of the line or the other, where the results are happening to the favor or detriment of one or a few specific groups of people. And the third one that we talk about would be a systemic effect, where this systematic effect would significantly reduce the economic welfare, either through a static or a dynamic efficiency. So what is happening, and is it happening on such a level to a certain group of people to alter the way that the economic system or the market is functioning? These are different levels of impact, and they need to be understood in relation to the behavior and the role of the entire system. So these are the three ways that we started to look into the cases that we chose. So what are the patent holdout contexts? So we created a little bit of a diagram. Started out with a diagram to think a little bit about how will we see who would be affected by patent holdout. So we thought about hybrid firms. So these were firms that could be operating companies, but they also do licensing as well. So they sell physical products and services, but also licensing. And of course, it could be pure non-practicing entities, those that are like specialized R&D entities that do R&D, but then license as their main business model. Then, of course, these would be the actors in the bottom two boxes that are owning their own IP. It could be that they transfer the rights of this IP or create an agent relationship with patent assertion entities. So they acquire from these two actors, and the patent assertion entity is the one that brings the case to court or starts the litigation if necessary. But these would be the different actors that would be in a situation of patent holdout. And for our study, we looked at those that are in the bottom two boxes. So for us, small or smaller technology firms are those where the plaintiff or the patent holder is an operating company or a non-practicing entity with its own IP. We looked to see when they were up against defendants that have a lot of litigation that are rather large. So in the third number here is the plaintiff is orders of magnitude smaller than the defendant. So the idea of own IP, having a model of licensing IP, but being of orders of magnitude smaller than the actor that they're competing with or they're litigating against. And then we looked at court cases where there was results coming. So the reason that we use this as a criteria to pick cases was that we wanted there to be some type of record. If the cases or things were just starting, there wouldn't be enough information to understand the case and to understand what's going on and to kind of test some of these ideas and theories about patent holdout. So in this case, so this was the first way we took a slice at all the different cases, and this produced about 12 or 13 cases from 2012. Wasn't that many cases that fit this criteria once you take out the ones that are just patent assertion entities and the ones that aren't, both small, very small versus large. And in this small group, even though it's not a statistically significant sample, it is interesting that there aren't that many cases that went to full judgment. But we can see that there was a mix of opcos, of hybrid opcos, and pure licensing or pure R&D firms. There was a significant litigation history, so 30 to 98 months and counting, going back to this time of litigation. Only one case of this has resulted in an actual payment. So that was the MCT versus Apple case. So even though all of these cases ended in some type of damages, only one time in all of these did someone actually get paid. 3 of the cases were vacated on procedural grounds after years of litigation. So even whether you agreed that the company, whichever company was right or wrong, the fact that it took 73 months to find out that the company suing didn't have standing, that's quite a long time to find out that the whole case is thrown out for procedural reasons. The defendants in most cases employed the PTAB, which started in 2012 and 13, to invalidate patents in suit, and in one case involved the ICT, which was Sonos. So in the end, we picked 2 cases to look into in more detail, and those were Sonos v. Google and Centripetal v. Cisco. We picked Sonos because it was a public opco with a hybrid strategy. It had substantial revenue up against a big tech competitor operating in the same or similar product market. We picked Centripetal because it was a VC-backed opco with multi-use technology, again, up against a very large telecommunications actor, Cisco, and operating in a large adjacent market. So quickly, if I go through some of the results from these cases, in the Sonos v. Google, it's probably important to start out and say that, as in the Centripetal case, there was a history of collaboration before litigation. So quickly about Sonos. Sonos was launched its first speaker in 2005. In 2013 and 14, it collaborated with Google for the integration of Google Play Music into the Sonos platform. In 2014, Amazon launched the first smart speaker, and this took this idea of the wireless speaker to another level. And of course, because Amazon launched it, then Google also started to launch its competing products. And while Google was launching competing products with Amazon, they were also competing with Sonos at the same time. Sonos, from between 2016 and 19, there was an integration of the Google Assistant into the Sonos platform. So while Sonos had created a very unique wireless speaker platform, they were also incorporating smart technology, smart assistants in, just in the way that the big tech firms were launching their smart speakers with their assistants. So that you can see, again, this technology convergence over time that we talked about earlier. On the screen here, you can see just an overview of the cases. So this case goes back and forth. Sonos asserts a number of patents in the beginning of 2020, and then also files at the ITC. So the case in the district court is stayed for the ITC case. Then Google files suit against Sonos on a number of patents. Then Sonos files suit with Google. Then Google files suit with Sonos again. And both Google and Sonos use IPRs, and they both use the ITC. So you can start to see from this, and we go into in our paper and we try to throw out a lot of information in a descriptive way so that people can see what's happened and can draw their own conclusions about the behavior and the impact. But you can see that a lot of time has gone by. So if I go to the next slide and give you some of the updates here, we can see that from the intrinsic challenges perspective of Sonos versus Google, they were put on notice in 2016. It's now 2023. That's 7 years of time. The court case has been ongoing for over 37 months, tens of millions of dollars on both sides. One could say that despite the size difference, Sonos has enough financial strength to be able to manage the litigation process. From the extrinsic challenges, you can see that the ITC exclusion order is being used by both parties, possibly as a substitute for using injunctive relief after eBay. Both sides use the PTAB, and this growth in multi-technology convergence from wireless to smart speakers plays an important role, as I mentioned. The patent holdout behavior, so there's multiple parallel international patent infringements initiated by Google as well. So in addition to what I showed on the first slide, there's also other parallel court cases internationally in Canada and the Netherlands, in Germany, France. But there is no evidence of bad faith behavior from the court, because the court case was stayed to go through the ITC, which is still in appeal. So there hasn't been the discovery in the main case to be able to determine, at least legally, about good or bad faith behavior. Though there has been people commenting just on what's happened, whether this is good or bad faith behavior. And when it comes to the impact, obviously for Sonos, the cost of litigation is extremely high. The disruption for business operations for a small company is very high. This court case doesn't even show up on the 10K form of Google. So it's not important enough to even show up on their regulatory filings. And there's, of course, a problem here when there is an overlap on the product market that while the court case is going on, infringing firms could potentially be stealing market share from the patent holder. So you have these kind of also indirect, not impacts that need to be considered as part of the overall understanding of the impact. We move on to Centripetal versus Cisco. I pop up the first one of the slides that Centripetal presented. And here, the key thing is to see again, now in 2015, they started to have communication. They signed an NDA in 2016. They became a technology partner with Cisco in 2016. Cisco was provided Centripetal's proprietary information and patents in 2016, and then Cisco launches their own product claimed to be using Centripetal's technology in 2017. The court case comes in 2018, and as Centripetal puts forward in their slide, this is their slide, that during this time period, Cisco visited their website 354 times and viewed 1,206 pages during this process. So both in Centripetal and in the Sonos case, there was a collaboration that started out before the litigation began. In this case, the intrinsic challenges, so infringement began in 2017 with no final decision yet, so a very long time. The court case took 52 months through the appeal, and then in the end, it was vacated over conflict of interest. So there was a fundamental difficulty of the subjective nature of the language. So if you look at the arguments start to come down to what does immediately mean or also mean. So again, going back to this idea that there's these intrinsic subjectivity. But also, despite the size, Centripetal was able to defend itself in court in this way, although it took a lot of money and a lot of time. And in the end, of course, the most strange thing about this case is that on appeal, the case was vacated. $2.7 billion judgment with enhanced damages was vacated because the wife of the judge had $4,000 worth of Cisco stock, which, if it would have fallen by $2.7 billion, would have meant a $60 loss. So they vacated the whole judgment, basically on the premise that the judge didn't wanted to spite his wife out of $60 because it was Cisco stock, not Centripetal stock that she owned. So the extrinsic challenges, so the difficulty to obtain injunctive relief in federal court after eBay was present. Cisco's did an IPR on 9 of the 11 patents in suit. And then again, the convergence of cybersecurity technology into network infrastructure, this technology change that causes people to need to upgrade their products in an innovative way. The court decided for willful infringement and enhanced damages and they applied the 9 Reed factors from the Reed case to determine that there was actual bad faith behavior. And then because of that, the impact, there was 2.5 times enhanced damages. So one of the questions you would ask as we go forward here is, if you get enhanced damages because patent holdout is seen through bad faith behavior, does this make the patent holder whole? Can you replace an injunction-based system with a system that has enhanced damages as remedies and still make it a system that works properly? This is a question that we can discuss later. All right, last slide. So after thinking about the received theory, applying it to the cases, and then thinking a bit about how would we move forward for a new theory of patent holdout, specifically for small companies, you find a few things, right? So first of all, the types of small technology firms that can experience patent holdout, it would be hybrid opcos, NPEs, but you could also say PAEs by proxy, because when opcos or NPEs don't have the time or the money to deal with the intrinsic challenges of the patent system, they will need to hand this over to PAEs or to be funded by external actors. And so theoretically, what is the difference if someone else takes it forward because the original owner cannot? I'm not sure that changes the theory that much, even though it does change the nature of the agent. Types of behavior in response. So when small technology firms have to respond to the situation of patent holdout, they're forced to litigate. That's one response. If they're not able to receive a license agreement, they can be unable to litigate or to settle for political reasons or because they don't have money or the time to deal with it. That would also mean that they would receive less than they should. They could be forced to settle because, again, they don't have time or money to handle it, which would mean they would receive less than they should. And of course, sometimes firms will fail because people won't receive money or follow-on funding because the community of investors doesn't believe that they'll be able to control their innovations with their patents. So these are the different types of behaviors that can come out. The important thing about this is that when you look to study to see how prevalent patent holdout is, you have to look at, you can't only look at the litigations like we did to find cases, you have to look even when people don't litigate and even when firms fail to find out why that is. Patent holdout behavior by alleged infringers. So we talked about the good faith versus the bad faith behavior. And we also discussed the idea of the rational behavior incentivized by the patent system. So are people acting in bad faith or are they acting within the weakened system that's in front of them to use? The last one here, we go into some depth in the paper, this rational behavior incentivized by market forces. So there can be market forces. Just to give one example now, the idea of the, hold on a second. The idea of the collective action problems, sorry for the delay. For collective action problems, for example, let's say that I would be willing to pay, but I'm only willing to pay if everyone else pays. So the fact that because of the market is set up that one person has to pay at one time, people won't pay until everyone else pays, which then puts more pressure on everyone not to pay. So there can be market factors as much as there can be patent system factors. And the last one here is the patent holdout impact. So what we find, from a circumstantial perspective, there is anecdotal evidence out there of patent holdout. Again, circumstantial evidence is important for the companies, maybe not as important for the overall economy. We need to look for systematic effects. There seems to be logical incentives produced by the patent system for both intrinsic or because of both intrinsic and extrinsic challenges. It seems to be logical that that patent holdout would be a rational way for an alleged infringer to behave and create a systematic effect. From a systemic perspective, there are also theoretical preconditions for industries where patent protection is critical for investment and leverage to enter the markets with large incumbents, but there needs to be more research to figure out whether there actually is a systematic and a systemic impact and how big that impact is. So I'll stop there. Thanks, Claudia.
Thank you. Very interesting data. I have already a list of questions that I have been coming at the time that you were presenting. So I'm gonna just start right away with them. And I remind those who would like to participate the Q&A tool, please feel free to write your questions and I'll be happy to later on ask them. All right, the first question I have here is, are patents now treated as minor, weak, or invalid? That is, are even strong patents weak in the current patent system? I guess they are meaning US patent system, but maybe they are meaning about all of them. So who wants to take this?
Matt, I've been talking. How about you?
Matt, you're muted.
Yep, here I am. Thank you. Yeah, nice job, Bo. Thanks for presenting the paper. So to answer the question, I believe through this work that Bo and I have done that it's very difficult now to have a strong patent. In fact, I don't believe there is really such thing as a strong patent because of this sort of inherent inequality between the large technology firms, particularly, and small technology firms. So my sense is that this is a systematic problem, and that the small technology firms have really suffered at the behest of the large firms, that it's very difficult to have a strong patent, even if it goes through the prosecution process at the patent office and the claims are granted through a very in a very direct way without a lot of back and forth. If the prior art was well searched, I still believe it's very difficult for the small players to really have a small patent, a strong patent. Excuse me.
I can just add that, you know, when the patent system becomes weaker, that's why we put the question in, or how weak are strong patents? Because if a patent system is really weak, all patents look weak, no matter what, in a weak system. I think it was Matteo Sabatini at Ericsson that wrote a paper that if you take enough bites at the apple in a subjective system, statistically, eventually one time, the number is going to come up. So validity is subjective, and if the system makes it difficult and allows you to over and over again challenge validity, it's going to be difficult for any patent to survive that. So we have to build a system that's a bit more resilient. You know, we have to balance it again.
I see. Okay, here I see another one. It seems to go for Matt. What are some changes that could be made to current patent law or the larger legal system to promote parties to settle out of court and reduce the frequency of holdout? Maybe you both say. Go ahead.
It's a good question. I'll start. I think the idea that it's very difficult to get an injunction is one of the aspects that could really impact the system and make the patent system stronger for smaller players. I think after the eBay case, it became very difficult for small players to participate because you didn't have this threat of an ability to stop the larger player from selling their product on the market. So from my perspective, that's the simplest change that could be made that really was stronger in the past and has been adjusted. But I think once the system started to move towards making it difficult for parties to get injunctions, it became much more difficult for small players to participate. I'll let Bo carry on from there.
I think that when it comes to these smaller technology firms and non-standard essential patents, the injunction is a very good way of forcing people to decide, should I pay for this or should I take it out of my product very quickly, right? And the courts courts in the United States have given people time in the past to do this. It doesn't have to happen immediately. So I think that it governs the process much quicker. Now, we could add something on the end. So we saw in the Centripetal case that they got 2.5 times enhanced damages. Had it not been vacated, we could have asked Centripetal, are you happy with the 2.7 billion? Did this, it took you a long time, but in the end, are you happy with the system? But right now, they're still unhappy, I suppose.
I suppose that too. Next question. Is there an incentive for alleged infringers to challenge all patents given the likelihood of success across multiple legal venues? If so, does this implicitly mean that only firms that can successfully litigate have valid patents?
I can start with that. It goes back to what we said before. I think that if the patent system is weak or offers a lot of opportunities to take a bite at the apple, unless you have the ability to defend yourself in so many different places, then you won't be able to play the game at all. And for small firms, that'll be very difficult. Let's say that some people will say, oh, but you can get money from litigation investment firms now, but you're going to have to pay them probably more than half of the money if you win. So right there, you're getting less than what was the true economic value, even if we use, Mark Lemley's definition. We're not getting that because you're getting less. You have to give someone else just to be part of the game. That means that the system is not operating properly.
Yeah, I think I just add on to that this idea that there's an entire industry now of litigation finance where hedge funds and private equity firms are raising capital for the sole purpose of helping smaller companies assert patents against larger companies is sort of indicative of the state right now for small companies. They're not capable of asserting their own patents, and if the costs are too expensive, the time it takes them off the focus of developing products and building their company. And so just the fact that there needs to be this additional layer that allows investors to participate that's highly risky in terms of getting return, I think is sort of proves the point that it is very difficult and only continuing to be more difficult until there's some new policy changes.
I think you can see the nuance too, Claudia, right? So let's say, we didn't include patent assertion entities in this study. We looked at people that created their own technology and either were hybrid or pure R&D firms. But if you can't afford to do something and you go to and you have to sell your patent or give it to someone else who can afford to do it, why would those actors be put in a negative category? It's just a proxy for the fact that the system doesn't allow the actor who owned it in the first place to be able to handle it. So it has to be nuanced in a better way.
I'm reading one of the questions and I'm thinking we can create a whole webinar on this, which is what is considered reasonable royalty payments?
Want me to go, Matt?
Yeah, this is your area.
Well, Matt and I talk about this a lot. It's funny, we have these little arguments, like we're like a married couple. We're going back and forth. My wife is listening to us and how do you know, right? This is, I think that patent holdup and patent holdout requires a frame of reference. And that is a bit of the problem, isn't it? Even in Mark Lemley's definition, he says it far exceeds the true economic value. Well, what is the true economic value? What is the reasonable royalty? And what you would like is that the system was strong enough to incentivize people not to go into litigation, but to negotiate amongst actors and show each other what they think and come, with inside each other's bargaining range and resolve it. That's the answer. The answer is what the companies come up with. Now, if they can't do that, then the court's going to have to do it. Is the court going to come up with the right number? Well, there is no right number. So they're going to come up with a number, and then you're going to run out of appeals, and that will be the number eventually. And what you would like is the system to be a bit afraid to go to the court so that people can negotiate and the market works, right? That's the idea.
So basically make it equally uninterested for both parties.
Both, yeah.
So
which is too weak or too strong. One side thinks, I'll take my chances. It has to scare both sides enough to negotiate. to find the number. The number is a negotiated number. It's not, you can't dig it out of the ground like a scroll and that's the number, right?
Yeah, and as Bo said earlier, the threshold for that number has to be above a certain amount for it to even make sense. So, you know, if the damage award is $10 million or $15 million, it doesn't make any sense for the plaintiff, because in the end, they probably will end up breaking even, making no money once they pay off all the people that were involved in the process. So it really, again, it incentivizes only those situations where the damages are massive and the infringement is really egregious.
I think this is one of the interesting issues, because we looked at the US, right? So now the unified patent court and the patent system is coming on in Europe. Maybe we will have a better version with less intrinsic challenges as we talk about. We'll see.
Interesting, because I have another question here, which is not exactly UPC, but I think another proposal that it's been discussed lately, which is establishing specialized patent courts. Could that help solving problems, or does it not play a role?
What do you think, Matt?
I think that it would definitely help solve the problem, but it still is dependent on the laws and the policy that's been developed. So I think a specialized court makes a lot of sense, particularly when you're looking at some of these situations in the U.S. where you have a jury in the Eastern or Western District of Texas that, and you're talking about these very complex technology cases, and I think a specialized court would really serve the system well, but it also has to be backed by a more balanced policy, so that there's some, equality between weak and strong. We don't want it to be too weak, and we don't want it to be too strong.
Yeah. So if you have to go to court, right, we're trying to create a system that makes people not incentivized to go to court unless there's really true uncertainty. And if that's the case, then if they do go to court, you would like to have people there that are very competent to handle this case. It's not good that in the U.S. so many times a patent case from the district courts gets overruled by the federal circuit. I mean, on matters of law, right? It's like on matters of law a lot of times, all the time, right? Has to be matters of law. So it's that's not a positive system where it can be predictable, and I think business wants predictable, right? People can, even a little worse or a little bad, but predictable is probably what people would take and adapt to.
I think this is one of the few things that I hear from several parts of the industry saying that they share the predictability and they need to know where this is going. The next question. It is my experience working with SMEs, if they are not hundreds of millions or billions of dollars at stake, litigation finance is not interested. Can we then say that there is no longer any possible reward for a $1 million idea?
Yeah,
there's like a black spot where you can't, it's like when I try to drive in rush hour traffic, I can only arrive at 7 or after 8:30. I can never arrive in between, right? Sorry, go ahead, Matt.
No, I think it's an interesting question. I think for me, and some of the advisory that we provide to startups, is that trade secrets have become much more important and much more valuable. And you may not have $1 million idea, but you may be able to implement a product or sell a product that's protected by a combination of patents and trade secrets. You need the patents to impress your investors and to get that initial seed capital in the door. But once you've checked that box, if you have some trade secrets or know-how that a potential acquirer might need, you certainly can have $1 million or a $10 million or a $20 million idea and be acquired by a larger company. But it requires this idea of intellectual property stacking, where you're combining rights, patent rights, trade secret rights, trademark rights, copyrights, etc. So I don't believe that people can't still execute and implement ideas because they're not worth hundreds of millions or billions of dollars. I think that there are plenty of companies that can be successful, but patents just play a smaller role maybe than they used to.
Mm-hmm.
Now, building on what Matt said, you're going to need to have this kind of multi-IP portfolio approach. But there can be a kind of indemnification range, right? There's a range where if it costs more money to get your money, then basically all infringers are indemnified up to that rate, right? So if it costs $1 million to get $1 million, then everybody's indemnified at $1 million of infringement, like an insurance policy. And that's and that can be bad for society if we need small actors to be able to make that money to grow into bigger actors, right?
I have one question here. It sounds quite interesting. I'm not sure who of you would like to take it, but I'm reading. Holdout impacts smaller technology firms more than the larger ones, as it is expensive, it takes a long time, and may not result in a reasonable award, all the while giving market share to a larger competitor. In light of the current system, does it make sense for smaller firms to spend money researching and filing patents? Would that time, energy, and resource be better spent on growing sales, on marketing, and or investing in additional R&D?
You touched on that, Matt. Go ahead.
Yeah, so in my experience, and as I mentioned, as we watch this system evolve, we are advising startups that we work closely with more and more that they do need to file a patent or a couple of patents. Again, institutional investors want to see that they've done that. But in terms of actually implementing and growing their business, we're often recommending that that the patent is just almost like a marketing tool. It's a way to sort of brand a product, say that it's patent pending or patented, but really focusing on growing market share, marketing and sales, building ideas for new products, figuring out ways to develop trade secrets or know-how, or establish relationships with third parties that make the company itself invaluable to a potential acquirer. So I spoke with a startup yesterday, and they have this sort of software for aggregating medical data. And with that data, they can be predictive about cancer in a sort of predictive analytics way. And they have ideas to file patents, and we encourage them to go forward with that. But what we suggested was the real value add that they could bring to the table was to establish relationships with medical universities to get data, to get as many data sources as possible. Because if they had relationships with 10 or 15 or 20 or 30 medical universities, and they were getting the data from them, and let's say those were exclusive relationships or even non-exclusive, but the combination of that data plus this sort of ability to stop others, arguably through a patent, is really that combination of those two things is what gives them an advantage and a stronger control position. So again, we encourage them to maybe spend less money and less time focusing on filing your patent and getting this broad patent coverage, and more of your time on establishing these relationships with medical universities.
Matt and I have argued about this point as well. Should you have patents or not? And of course, one thing to say is it depends a bit on the nature of the technology. If it's something that costs a lot to create and is very easy to imitate, then patents still, I think, are critical. We've asked people, we said, if you, in the weak patent system now, the patent system weak, why should you patent at all? And some people say, well, if it's something that's on the line that we might have patented before or not, we might not now and try to keep things secret. But if it's something that needs to be patented, we might do more patents because we know that we need a whole portfolio out there. So because we know some of them are going to go down in this system. So you actually, in a weak system, can get more patents because people need a portfolio approach to try to handle that. So these are so as a researcher, okay, are we looking for less or more, or less and more? It's hard for us to find, but I think that the answer is always in the nuance.
You're starting to talk as a lawyer with it depends. spending too much time with lawyers.
Economists are the same, right? You know, on one hand this, on the other hand. Yeah.
Yes. Okay, I think we still have time at least for one more. Let me see. Given the lack of very large damage awards that have not been overturned, what is the highest settlement amount that a large actor is willing to pay pre-litigation?
Yeah, I can start that one, Matt. Is that okay?
Sure. Yeah, absolutely.
This is an interesting one because this is a little bit of psychology, isn't it? Let's say that you're, when I think about these, you know, let's say someone comes to you and you've done some big innovation and you're working with a company that sells a lot of products. So the number, if there is an infringement, the number is going to be high. So you would go to the legal person and say, well, we just got the letter about infringement and they want $400 million. Which person is going to go to the board of their company nowadays and say, I think we should pay 400 million? Even if they thought it could be more, who's going to do that? I don't think that there's evidence out there from what happens to people who try to collect this money that makes people think we should pay without putting up a rather large fight. What do you say, Matt?
So I'll answer more directly and specifically in my experience in talking to lawyers and more recently, in fact, I think in general, companies are willing to write a check for about $20 million. And after that, they're not interested anymore at the maximum. They wouldn't go beyond that number. That's a number where I think lawyers and attorneys and litigators are telling clients, hey, you know, this would be the highest number that you could get offered from a big, technology firm.
We have here a comment. Maybe you can comment on the comment very quickly, stating, surely the economic impact of the patent holdout is that the strong become stronger and they wipe out any competition or diversity. This must lead to the overall weakness of the system, making it increasingly narrow, conservative, and subject to serious problems when the context changes.
Right. No, it's a good point. And that's the issue, right? That's the reason why we looked into small firms. You know, big firms need the patent system as well. Pharma in standard essential patents, they're critical, as we've talked about. But big firms also can handle themselves a bit easier. It doesn't mean that we shouldn't, deal with those issues as well. But small firms, Elon Musk, he said recently that patents are for the weak. Yes. That's why you need the patents. For the small firms, they're weak. They need. It's like David. Oh, David, why do you bring that sling to the fight? Yeah, I need something. Right? It's you need the smaller actors need the patent, and we need them to have something that gets them into the game that can compete, because we know that innovation comes from these small actors. Almost all the companies that we talk about were small ones in that situation. People didn't just plop down trillion-dollar companies. They grew, and we have to incentivize those. And if we don't do that, as the commenter says, we are obviously going to pay the price in the future.
And I'll just add that it again, it reinforces this idea that trade secrets and know-how are so critical to capturing value, because without it, you really don't have a leg to stand.
Well, thank you so much. I think we could stay here the whole day. I keep seeing more and more questions. Unfortunately, we didn't have time to go through this. I apologize. Thank you so much to Bo and Matt for sharing your knowledge, your expertise, and those sending comments. Also, thank you for the audience for staying with us the whole time and attending this webinar. And tomorrow, you will receive, today or tomorrow, an email inviting you to complete a 1-minute survey about this webinar, and we will really be thankful if you could give us your feedback. And as explained before, a recording of this presentation will be available at Forepi Council website tomorrow. And please don't forget to register for the upcoming webinar. And this one is called From Semiconductor to Embracing a Better Life, IP Models for an Innovation Ecosystem, at IMEC. And you can find more in our website at 4ipcouncil.com. Again, thanks to all of you. It's been a pleasure to be in this webinar, and look forward to seeing you in the next one. Bye-bye.